Afternoon, everyone, and welcome. My name is Alex Saleh, and I'm the managing partner of GLA Co. Thank you for being here today. I know many of you are managing live projects, active contracts, and urgent client questions in real time. This is precisely why we have convened this webinar today, not as an academic exercise, but as a direct and practical response of what is happening right now across the Gulf. Let me start with a moment of candor. We did not plan this webinar months in advance. We planned it just a few weeks ago with the beginning of the conflict, because what is unfolding between the US, Israel, and Iran is not a slow developing situation. It's a live crisis, and it's already hitting GCC contracts hard. We are seeing shipping operators reroute or suspend voyages. The Straits of Hormuz, one of the most strategically vital maritime corridors in the global energy market, has been classified as a high-risk zone. War risk insurance is being withdrawn or dramatically repriced. Airspace restrictions are affecting the movement of personnel and cargo. Supply chains that were under pressure are now at a breaking point. And across Kuwait, the UAE, Qatar, and Saudi, employers, contractors, subcontractors, and financiers are all asking the same question. What do my rights under this contract actually mean right now under Arab civil law? This is the question we're here to answer. At GLA, we're the leading regional law firm specializing solely in Arab civil law, with 180 lawyers on the ground across the GCC and Egypt. We're not a firm that parachutes into the region when a crisis arises. We live here, we practice here, and we've been practicing Arab civil law in the course of cassation, on major construction projects, in government negotiations, and in cross-border commercial disputes for over 4 decades. And I want to say something specific about what this means. Our lawyers simply do not know what the law says. We understand how it was built. The civil codes of Kuwait, UAE, Qatar, Saudi, all 4 of the jurisdictions our panelists represent today share a common intellectual architecture. They derive from the Egyptian Civil Code of 1948, itself the masterwork of Abdul Razak al-Sunhuri, the greatest jurist in the history of modern Arab law. When Sunhuri drafted these provisions on hardship, on force majeure, on the automatic dissolution of impossible contracts, he was not writing boilerplate. He was synthesizing a millennium of Islamic jurisprudence and the best of Western civil law tradition into a unified, coherent framework of justice. Our lawyers understand Sunhuri's reasoning, not merely his words. We understand what the courts of cassation have done with those words in the decades since. And the depth of understanding is what clients need at a moment like this. We have litigated these exact types of cases: force majeure, hardship, impossibility of performance. We have argued these doctrines before the courts of the region through oil price collapses, regional political crises, blockades, global pandemic, and more. This is not new territory for us. Bottom line, anyone can read a civil law. Our team knows how these laws were developed and how Arab courts interpret them. You know, everyone has a story. At a personal level, I've been in the region for over 30 years, splitting many of those years between Dubai and Kuwait. I arrived actually in Kuwait in 1994 in October, fresh from Georgetown Law School, only weeks into my country when Saddam Hussein began massing troops on the border. The world called it the October Surprise just a few years after the first Gulf War. The invasion never came. The crisis passed. This was my introduction to the Gulf. And in the 30 plus years since, I've been present for every major regional disruption we faced. Oil prices at $10 a barrel in 98, the US-led invasion of Iraq in 2003, the global financial crisis, the Arab Spring, the Qatar blockade, COVID-19. Each time the predictions were dire, each time the GCC emerged stronger. This crisis will pass too, but what never changes through every cycle, every disruption, every escalation is this: contracts come under pressure, and the parties must understand their rights. The truth was as real in 94 as it is today. Today's session is going to be structured around 5 questions that our panelists, our GLA team members from Kuwait, the UAE, Qatar, and Saudi, and the region will address in depth. More specifically, we have Hagi Taha, partner from the Saudi practice, Mohammed Al-Awadi, partner in the Kuwait office, Dean Jaludi, partner and head of office for Qatar, Khalid Abu Rabi from the UAE office, and May Al-Mahdi with the dispute resolution team. Now, before I frame each question, let me give you the simplest way to think about what we are discussing today. I always tell our clients when we represent a contractor, we carry two tools. The doctrine of unforeseen circumstances is my sword. It's the offensive weapon that we use to go to court, sue, and collect additional damages when performance becomes excessively burdensome and the original bargain has become unjust. Force majeure, on the other hand, is my shield. It's the defensive tool I use to protect the contractor so they do not have to perform or comply with the shield at all, because performance has become genuinely impossible. Sword and shield, one attacks, one defends. Both are available under every Arab civil law in the GCC. Now, let me briefly frame what is at stake at each of our questions. Our 5 questions will take you through the full spectrum, from the sword, the doctrine of unforeseen circumstances, which empowers courts to rebalance contracts, to the shield, force majeure, which excuses performance entirely when it becomes impossible, to the legal consequences when impossibility triggers automatic dissolution, to the critical asymmetry that hardship and possibility cannot be contracted out, while force majeure as a liability defense can be, and finally to practical steps you or your clients can take right now. So without further ado, let us begin. We're going to start with the first question, just to get right into it. And by the way, at some point, we're going to be taking questions from the participants. So please feel free to type in any of your questions into the chat. And at a certain point, as we finish the questions, we're going to get into any questions that you may have. Well, my first question actually goes to the doctrine our clients are most likely to encounter right now. The conflict has driven up shipping costs, reprised war risk insurance, and disrupted supply chains across the GCC. In most cases, performance has not become impossible, but it has become far more expensive and burdensome. This is the territory of our first doctrine, the doctrine of unforeseen circumstances. It asks not whether performance is possible, but whether it's become economically devastating that it would be unjust to hold the debtor to the original bargain. And what we seek to do with the panelists today is we're going to tell you what the law is, but then we're going to tell you the intellectual background from Sunhuri, who developed these laws, and finally how the courts of cassation in our region are actually interpreting this. This gives us the best understanding to understand your rights. So Mohammed will take us through the civil law text, May will give us the Sunhuri intellectual framework, and Hagi will address the case law. Mohammed, tell us about the civil law text with respect to this doctrine.
Well, Alex, starting off, we see a lot of synergy in the laws we're going to be talking about today. I think with regard to this doctrine, which is codified in all 4 GCC jurisdictions we are covering today, Article 198 of the Kuwait Civil Code, which is seen as the most prominent, most foundational of the 4, provides that when general extraordinary events arise after contracting, which could not have been foreseen at the time of signing the documents, and which renders the performance oppressive to the debtor, such as to threaten him with heavy losses, the judge may reduce the oppressive obligations to a reasonable degree, which means that the financial equilibrium of the contract is reassembled. It happens with 2 ways, either by narrowing down the extent or awarding a balanced price increase. Critically, this article ends with any agreement otherwise shall be null. We have seen equivalent provisions in the 4 jurisdictions, especially under Article 224 of the new UAE Civil Transactions Law, Article 171 of the Qatar Civil Code, as well as Article 97 of the Saudi Transaction Law. For this unforeseen circumstance to happen, we have to have 5 conditions. First of which, the events must be general. They must affect the broader economy and not only the debtor himself or the parties of the contract. Second of which, it must be unforeseen. Based on the name itself, it's an unforeseen circumstance, so you must not know of this event or foresee it during the time before entering the contract. Third of which is it must be supervening. It means it has to arise after the contract was formed. Another point is that it must be the performance must be burdensome without making it impossible. We will talk about impossibility at a later stage. The final event that must happen, it must not attribute to the debtor's own fault. The remedy for this clause is not termination. It is rather be seen as judicial rebalancing. The court narrows down the obligations or increases the counter obligations. The new UAE law permits rescission. One particular note, Saudi Arabia has a unique way of dealing with this. The debtor must first call on the other party to negotiate in good faith and continue performing before going to court. For all the other three jurisdictions we're talking about today, the court may be approached directly without any talks between the two parties beforehand.
Excellent. May provide us Sunhuri's framework on this issue.
Well, thank you, Alex, and thank you, Mohammed. Building on the statutory text we've just heard, let me take you to the intellectual foundation. So Sanhui treated this doctrine of unforeseen circumstances or hardship in al-wasit not as a footnote to contract law, but as a deliberate exception to pacta sunt servanda, the binding force of contracts, grounded squarely in justice and equity. So his words in volume 1 are unambiguous and worth quoting. It would be unjust to respect the contract in such circumstances, and justice requires working to help the debtor and save him from ruin. And save him from ruin here, that is the threshold he set. This is not about making life easier for a debtor who made a bad commercial debt. It's about preventing injustice when the ground shifts beneath a contract. He defined 3 key terms anchor the entire analysis together. First, the event must be general and extraordinary, meaning that the event must be systemic. So whereas pandemics, revolutions qualify, but a contractor's own cost overruns do not. The second term is it must be unforeseeable. And this is an objective test measured by what a reasonable person in that position would have anticipated when the contract was signed, not in hindsight. And for our audience today, this is the real battleground. The foreseeability question is where most of these cases will be won or lost. Third, the performance must be oppressive, threatening the debtor with a devastating loss grossly out of proportion to what anyone contemplated at formation. So the mere inconvenience, reduced margin of profitability, or increased costs alone will not cross that threshold. That's on the definition side. On remedy side, Sanhui also gave the judges 3 gateways as tools, not just one. So a judge in a court can reduce the onerous obligation. He can also award a balancing increase in the counter obligation, or, and this is the tool that practitioners often overlook, that it can suspend performance altogether when the disruption looks temporary. So the judge distributes the burden equitably between both parties, and we can say that these remedies achieve the balance of no one walks away whole, but no one is ruined either. And one last point that it connects directly to what we will discuss later, that Sanhui was unambiguous that this belongs to public order. So parties cannot exclude it in advance or contract out of it, and any such clause to the contrary is void. And also we need to understand what this means in practice. It means that the judge does not merely interpret your contract, the judge modifies it, and that's a remarkable power, and it's not optional.
Excellent. And Hagi, how have the courts of cassation actually interpreted this clause?
Actually, the highest courts in the 4 jurisdiction have reviewed and confirmed this doctrine, having consistent, though not identical, rules around its required application. For example, in Kuwait, the Court of Cassation has confirmed that Article 198 of the Civil Code gives the judge a legal power that can only be used when certain conditions are met. Most importantly, the condition that performance causes a heavy burden, risking major loss. The court has made clear that the level of loss is actually measured objectively, based on the subject matter of the contract and the nature of the obligation, not the debtor personal financial situation. Simply losing profit or missing out on commercial gains is not enough. The loss must be unusual and must seriously upset the balance of the contract. Qatar's Court of Cassation takes a similar approach, drawing a clear line between normal business risk and unforeseen events, where an unexpected event occurs after the contract is signed that the parties could not have predicted, and it goes beyond ordinary commercial loss without making performance impossible. The judge may, on the debtor's request and after balancing both parties' interests, reduce the obligation to a fair level. Only the court can approve any change. a debtor cannot adjust obligation on their own. The UAE courts of cassation follow the same reasoning, requiring the debtor to show that performance risks serious loss due to truly unforeseen events. The Abu Dhabi and Dubai courts require a direct link between the unexpected event and the burden on the specific obligation. General claims of economic difficulty are not enough. Egypt's position is similar. The event must be unexpected, wide in scope, and must risk severe loss to the debtor. Egyptian courts have also held that this doctrine is required by law, and any contract term excluding it would be considered invalid. Finally, across all of these countries, the highest courts follow broadly the same logic. The doctrine allows a judge to reduce contractual obligation where an unexpected event makes performance difficult, though not impossible, and causes or risk major economic loss beyond normal business risk. Whether such an event is genuinely unexpected is a question of fact of the trial court, and where proven, the remedy is for the court to rebalance the parties' obligation.
Excellent. I think this is the doctrine that is most difficult for a lot of Western common lawyers to understand. The idea that a judge can simply redraft the terms and conditions of an existing contract if certain elements are had. This is something that's foreign and actually alien to courts outside of the Arab civil law world. Anyway, in any event, there's two takeaways on it as a whole. First, hardship applies when performance is hard. The moment it becomes impossible, then you move on to force majeure, which is question number 2, which I just want to get into right away. Now, this force majeure sits at the other end of the spectrum. When hardship asks whether performance has become hard, force majeure asks whether it becomes impossible. This is a categorical divide, not a difference of degree, and it carries fundamental different legal consequences. In the current conflict, rising costs, rerouted shipments, and insurance repricing are typical hardship territory. A military strike that destroys a facility, a government prohibition on exports, or an airspace closure that prevents delivery. Those may be force majeure. Dean will take us through the civil code. May will give us Sunhuri's 2-part test, and Khalid will address the courts. Dean?
Sure. So force majeure is interesting because across the region, it's generally defined not only by what it is, but by what it does. So in the strict sense, a force majeure is simply an act of God or a third-party act, which is beyond the control of the parties, such as extreme weather events, pandemics, armed conflict, or other serious external events. But that alone does not make something a force majeure. A force majeure event must also render performance of that particular contract impossible. Not just difficult, not just expensive, but impossible. Whether that's factually, physically impossible, or legally impossible, or some other form of impossible. That being said, even the word impossible can potentially be a bit complicated because we would then have to consider things like partial impossibility or temporary impossibility, which we'll discuss in more detail later. Practically, it's important to be aware of a couple of legal issues that are associated with force majeure events under the local laws across the GCC. So the first legal issue to consider is liability. In Kuwait first, Article 233 of the Civil Code provides that an obligor is not liable for compensation if the harm arose from a foreign cause beyond their control. And that expressly includes force majeure, act of God, third-party act, or act of the other party. And there are similar provisions across the region, such as Article 249 in the UAE law, Article 204 in the Civil Code of Qatar, and Article 125 in the Saudi Civil Transactions Law. The second legal issue to be mindful of is that a force majeure event would lead to automatic dissolution of a bilateral contract, at least. In Kuwait, this would be Article 215 of the Civil Code, which provides that in the case of bilateral contracts, if performance becomes impossible due to a foreign cause not attributable to either party, in other words, a force majeure, then both the primary obligation and the counter obligations would lapse, and the contract would be immediately revoked. There was no court judgment required in these cases, and the parties don't have to take this to court or litigate. The contract would simply be terminated by operation of law. This is not unique to Kuwait either. There are similar provisions across the region, such as Article 236 in the new UAE law, or Article 188 in the Civil Code of Qatar, or Article 110 in the Civil Transactions Law in Saudi. That being said, it's important to note that in some instances and in some contracts, the parties may preemptively agree to opt out of these statutory protections. Specifically, parties may contractually agree that the obligor would bear the risk of force majeure events. For example, Article 295 of Kuwait Civil Code and Article 258 of Qatar Civil Code both expressly permit this risk allocation. And I suspect that right now, many people attending this webinar may be checking their contracts to see if they have these provisions. And finally, as we mentioned before, very briefly, parties should note that even the term impossible may have its limits. To the extent that a force majeure event renders performance impossible, but only for a limited period of time or only for a limited part of that contract scope, then the consequences are a bit more complicated. And this is not simply an academic exercise. In fact, as many of you have probably noticed from the news, a very prominent regional energy company announced that they would be invoking force majeure, but they made it clear that this did not mean that they would terminate their contracts or completely excuse themselves from performance. Instead, they said that they would just need a few years, most likely, to deal with the consequences of recent events, and then they would return to deliver on their obligations.
Excellent. Right. May, Sunhuri's framework on the same?
Yeah, thank you, Alex, and thank you, Dean, for walking us through the two statutory mechanisms, the liability defense and the automatic dissolution. And from that, let me show you now the analytical frameworks and Sanhouri constructed underneath them. That everything starts with what he called the foreign cause, a cause or an event in which the debtor had absolutely no part. And for that event to qualify as force majeure, two conditions must be cumulatively satisfied. First, unforeseeability, and it's assessed objectively at the time of contracting, not in hindsight. And here's the practical point for today's discussion. The more visible the geopolitical tension was when your client signed the contract, the harder this argument becomes. And for the second condition, which is irresistibility, meaning that the event must make performance genuinely impossible, not more expensive, not slower, not commercially unattractive. And Sanhouri's own words are the clearest statement of this division. And I'm quoting, "It's not sufficient that performance becomes onerous as long as it remains possible, the obligation is not extinguished." So that single sentence is the dividing line between hardship and force majeure. Now, on the automatic dissolution that Dean just described, Sanhouri drew a sharp line between that and the judicial rescission. When a debtor fails through their own fault, the court issues a constitutive judgment creating the rescission, and notice is required and must be given first in that case. But when force majeure renders performance impossible, the contract dissolves automatically by force flow and no notice is needed because, as Sanhouri wrote, notice is only conceivable if performance is still possible. So if the parties later go to court, the court's role is purely declaratory, meaning that it confirms what the law has already done. And for the current conflict specifically, Sanhouri also explicitly recognized war, government prohibitions, and sudden sanctions as potential force majeure events. But the burden of proof falls squarely on the debtor, and as our next panelist will confirm from the case law, it is a very demanding burden.
Okay. And Khaled, give us the Court of Cassation guidance on this point.
Thank you, Alex, and good afternoon, everyone. So if we start with the courts across Kuwait, Qatar, the UAE, and Egypt have built a consistent body of case law in force majeure, requiring proof that performance is truly impossible, not just harder or more expensive. And this is important. This is much higher bar than the hardship doctrine. Now, if we take Kuwait as an example, the Court of Cassation requires two things. The event must be impossible to predict and impossible to overcome. The test is objective. It must be something even the most careful person could not have seen coming. And it must make performance impossible for anyone in the debtor's position, not just the debtor. And we actually saw this clearly in COVID-19 cases. The pandemic made running restaurants very difficult, but not impossible. So the court cut the rent to 1/3 rather than ending the lease. Qatar follows the same approach. Performance must become completely impossible due to an outside cause, not just very burdensome. The debtor must prove this, and if they cannot, they remain liable. Also, this is a key point. Qatari courts have noted that business involves risk, and traders are expected to plan for economic ups and downs. So price rises alone do not count as force majeure. If we move to the UAE, the courts apply the same higher bar. In COVID-19 cases where government orders made performance genuinely impossible, such as the physical closure of an island, stopping a restaurant from operating, the court accepted force majeure and allowed termination. But where the pandemic only made things harder, like construction delays from supply chain problem, the court rejected force majeure and applied the hardship doctrine instead. So to summarize, across all 4 countries, the message is the same. Force majeure is a narrow doctrine kept for true impossibility. Courts will not let party use it as a way out of contract that have simply become less profitable and more costly, but remains possible to perform.
Excellent, excellent. Well, 3 takeaways. The courts require absolute impossibility, not difficulty, not commercial inconvenience. The burden's on the debtor and is demanding. The foreseeability clock runs from the time of contracting. Parties who contracted during obvious regional tension face the hardest arguments. And the automatic dissolution rules cannot be contracted around. We now move on to question 3. What happens legally when a contract does dissolve? Questions 1 and 2 map the spectrum. Question 3 addresses the endpoint. When force majeure is established and performance becomes generally impossible, what happens to the contract and who bears the loss? This is not academic. When a facility is destroyed, when an export is prohibited, when a route is permanently closed, what are the legal mechanics? Mohammed, why don't you start off with the civil law background?
Well, Alex, according to Article 215 of the Kuwait Civil Code, in bilateral contracts, if performance becomes impossible for a foreign reason not attributed to the debtor, both obligations lapse, meaning the contract is automatically revoked. 3 elements are critical. First of which is dissolution is automatic, no need for a court judgment, no need for a notice. Second, both parties' obligations lapse together. The primary obligation and the counter obligation lapse at the same time. The debtor cannot ask for payment and the creditor cannot demand performance. Third, where impossibility is partial, the creditor on his own may elect either to enforce the remaining portion or apply for full rejection. Article 216 of the same code governs consequences. The contract is deemed as if it never existed, and the parties are back to their pre-contractual positions. Saudi Arabia, on the other hand, adds a critical distinction there. For continuous contracts, dissolution has no retroactive effect. It is only a prospective application. An important point to note is in Article 236 of the UAE Civil Transactions Law, which is seen as the most sophisticated of the 4. It expressly addresses certain scenarios. First of which is the total impossibility, and it results in automatic dissolution, just like the other governing bodies in the GCC. Second is partial impossibility. Either party here may invoke extinguishment or petition for full rescission. Third of which, and I think is the most important, is for temporary impossibility in continuous contracts. Either party may seek suspension, modification, or rescission. Why I say the third is the most important today is because it is very relevant and we see it on day-to-day basis with regard to these events. Because of airspace closures, temporary blockades, and sanctions that are modified from time to time. The UAE framework now expressly addresses all these points we are facing today.
Excellent. May I give us the Sanhuri framework?
Yeah, well, everything we have just heard, and thank you, Mohammed, for that, flow from one principle that's Sanhuri grounded in the maxim, no one is obligated to do the impossible. But Sanhuri actually did not stop at the principle itself. He drew 4 distinctions that are essential for anyone advising on the current situation in the GCC. And I want to walk you through them because each one matters for the situations our clients are facing right now. So the first distinction is original impossibility versus supervening impossibility. Only impossibility that arises after the contract was formed triggers the solution, and if impossibility existed from the start, the contract is void and was never valid. And the second distinction is absolute versus relative impossibility, and this is the one that courts rely on more heavily, because only absolute impossibility for anyone in the debtor's position extinguishes the obligation. So if a party cannot perform because of their own limitation, the obligation survives, as our next panelist will discuss, and this is exactly the standard the courts apply. The third distinction is natural versus legal impossibility, when a government prohibition or sanctions regime constitutes legal impossibility carrying exactly the same consequences as physical destruction. And the fourth distinction is permanent versus temporary impossibility, and this is maybe the most practically relevant today, because temporary impossibility merely suspends the obligation and only permanent impossibility extinguishes it. So that fourth distinction is directly relevant today, and think about it in the context of airspace closures and sanctions that may be temporary in nature. On the restitution, Sanhouri was clear that once the contract dissolves, it is deemed as if it never existed, and mutual restitution is required. But here's a practical point for the construction EPC practitioners in this room. Where a contractor has partly performed before the solution, the entitlement to compensation for that work does not rest on the dissolved contract. It cannot, because the contract is gone. It rests on the principle of unjust enrichment, which is a separate legal basis, and it must be pleaded separately.
Excellent. 3 quick takeaways on this. Automatic dissolution is not a remedy. It's an operation of law. Clients should not wait for a court, but must document the impossibility contemporaneously and meticulously. The restitution obligation is immediate and must be analyzed at the moment of dissolution, not afterward. And the continuous contract distinction between Saudi law and the new UAE law is commercially decisive. For a long-term project and service agreements, past performance is preserved. Only future performance is released. We're going to just move on now to question number 4. Every transactional lawyer in this room is likely asking the same silent question. Does it matter what the law says if the contract says something different? Can sophisticated commercial parties simply opt out of these doctrines? The answer reveals a critical asymmetry in the law, one that applies regardless of how carefully your client has drafted the clause, and regardless of whether you're looking at a FIDIC regime or a bespoke government form. Mohammed will set out the contractual exclusion framework. May will look at Sanhouri's rationale, and Hagi will address the courts. Please, Mohammed.
Well, Alex, the 3 doctrines we're talking about today are not equally waivable. The asymmetry is stark and must be memorized. Hardship cannot be contracted out of. Every code states that. We circle back to Article 198, which we previously discussed initially, and it says, in wording, any agreement otherwise shall be deemed null. Article 224 in UAE, Article 171 in Qatar, and Article 97 in KSA, all bear the same meaning. A fixed lump sum, an immutable pricing clause, a risk matrix that allocates all fees to the contractor, none of these can extinguish the statutory hardship right. Impossibility rules are mandatory. Parties cannot automatically sustain an objectively impossible obligation. Force majeure, on the other hand, is a liability defense, however, cannot be contractually allocated. Article 295 in Kuwait, Article 258 in Qatar, and 174 of Saudi Arabia all expressly permit parties to agree that the debtor bears force majeure risk, with one exception in Qatar, in which the waiver is unavailable in adhesion contracts. We go to, I think, the favorite mechanism, which is FIDIC, the FIDIC regimes. Force majeure tests require that the event must be beyond the party's control, unforeseeable, unavoidable, and not to attribute to the other party. War, invasion, and acts of foreign enemies are typically listed as qualifying events. Many clauses impose a geographical limitation, meaning that the events must occur at the country of which the works are being held at. And here is the problem. The current conflict is centered on Iran, but affecting the entire GCC. Whether regional disruptions originating outside the project country qualifies as a question of contractual interpretation that must be resolved on the precise wording of the contract itself. With regards to relief, and I think this is the most important, general force majeure typically provides time only, which we know as excusable delay. War-related events qualify as employer risk events, may provide time and cost remedies, which is seen as remedy delays. The distinction is commercially decisive and must be identified immediately.
Okay. May, can you briefly give us Sunhuri's rationale?
Yeah, sure. What we have just heard is where Sanhuri reasoning becomes most practically significant for everyone, whether practitioners or clients. He started with the pacta sunt servanda, the binding force of contracts, and he accepted it unreservedly as a foundational rule. But he was equally clear that freedom of contract has a ceiling, and that ceiling is public order. Why did he place hardship above that ceiling? Because he gave 3 reasons, and they are worth stating because they explain why no amount of sophisticated drafting can override this doctrine. The first reasoning is justice. You cannot allow a party to waive or sign away in advance a protection that is designed to prevent financial ruin from unforeseeable events. The second reasoning is equitable risk distribution. It's when something extraordinary strikes, so the burden must be shared, not preemptively shifted entirely onto the weaker party. And the third reasoning is systemic stability. So in war times or economic crisis, the social interest is better served by orderly judicial adjustments of contract, not by mass termination or commercial collapse. But Sanhui drew one critical line that practitioners must understand. The prohibition is on advance waivers only. Once the hardship event actually materializes, parties are entirely free to negotiate their own adjustment, settle their claim, or even release each other. So the public order character restricts or blocks the prospective exclusion. It does not block retrospective settlement. And in plain terms, your client cannot sign away or waive hardship protection in the contract today, but once an event occurs, they can negotiate freely. And for construction contracts specifically, which I suspect was where most of the questions will arise, Sanhui addressed this directly in Volume 7 of Al-Wasit, stating that a contractor cannot demand a price increase simply because materials have become more expensive. Pacta sunt servanda again holds for ordinary market movement. But where general exceptional circumstances have collapsed the financial equilibrium of the contract, the judge may, and he actually has the power, to increase remuneration or order rescission. And that judicial power cannot be excluded by any contractual clause, regardless of how sophisticated the drafting was.
Okay. And Hagi, give us the Court of Cassation guidance on this doctrine.
Absolutely. Actually, the case law across the GCC and Egypt supports a clear split between hardship and force majeure when it comes to contracting out of these doctrines. In Qatar, the Court of Cassation has confirmed that under the hardship doctrine, the court's power to rebalance obligation remains even when the contract fixes prices or places all risk on one party. At the same time, the court has upheld the parties' freedom to agree on force majeure terms, including placing force majeure risk on the debtor. Kuwait and Egypt take the same view. Both treat hardship as a matter of public policy, meaning the court's power to reduce a heavy obligation cannot be removed by contract. In Egypt, any clause attempting to exclude this protection is treated as having no effect. However, for force majeure, parties are free to agree on how to share that risk, and the courts would respect those agreements. In practice, this means that well-drafted force majeure clauses, including those in standard form like FIDIC, can divide risk between the parties, but they cannot take away the court's built-in power to rebalance obligation in cases of hardship, and they cannot keep an obligation alive that has become truly impossible to perform.
Excellent, excellent. We're just going to jump straight into the last questions because we see a lot of questions in the chat that we want to get to as well. And for me, this is the question that all our clients are asking. Project agreements are in the ground. EPC contracts are mid-execution. Supply contracts are under acute stress. The question is not theoretical, it's immediate. In most situations our clients are facing today, performance remains technically possible, has become significantly more expensive. This is hardship territory, which means the remedial path is judicial rebalancing, not automatic dissolution. But the analysis is always fact-specific and contract-specific. May will address the project and EPC contracts, Khaled will address supply contracts, and Dean will talk about evidentiary preservation, financing, and dispute readiness, the dimension most consistently underinvested in a crisis like this. May, tell us about the project contracts.
Yeah, sure. In projects and APC contracts, parties may consider the following action, and for sure, let me turn to the project and APC contracts because this is where most of the practical pressure sits right now. So first, classify. Before any other action, determine whether the specific disruption affecting your project obligations amount to whether it's a force majeure or hardship, because the answer determines your entire legal strategy. So if sanctions-related prohibition, for example, have made procurement legally impossible, or if an airspace closure physically prevents mobilization of critical equipment, you may be in force majeure territory. But repriced war-risk insurance, rerouted vessels, or increased material costs, these are most certainly hardship. So get the classification right first, and everything else follows from it. Second, to get your protective notices immediately out. So under FIDIC regime, for example, the clock is 14 days from your awareness of the event. And this deadline is not aspirational. Missing it can be a fatal to a claim regardless of merits. So send the notice now, refine it as the situation develops, and be specific, because a vague reference to regional conflict, for example, will be challenged. So you must link the disruption to the specific obligation it actually affects. Third, go back to your force majeure clause and read it carefully. Does it actually covers what is happening? Because many clauses have a geographical limitation requiring the event to occur in the country of the works. So if the disruption originates in Iranian waters or airspace, your clause may not reach it. So check whether the contract distinguishes between general force majeure, which typically provide time only, and employers' risk events, which may provide time and cost. Also, know your termination threshold, because under FIDIC regime, 84 continuous days or 140 cumulative days may trigger termination rights, but be careful because any premature or wrongful termination at the same time is a repudiatory breach. And also, you need not to limit yourself to force majeure or hardship, because most well-drafted APC contracts already contain other mechanisms that may provide relief without having to prove impossibility or oppressive loss. So check the change in law clause if a new sanction, export, restriction, or regulation was enacted after the contract's phase date, and it may qualify as a contractual change, opening the door to time extension and price adjustment. So review the extension of time provisions separately. Grounds like employer order changes, suspension of works, and changes in law each stand on their own and may be triggered without proving force majeure. And lastly, consider whether acceleration provisions can convert time entitlements into cost recovery through negotiation.
Excellent. Khaled, tell us briefly about supply contracts, what we should be doing.
Well, as a matter of fact, supply contracts are currently under a significant pressure, including rerouted shipping, increased war risk premiums, airspace restrictions, and rising energy costs. But in reality, in most cases, performance remains technically possible, just at a significantly higher cost. And this is where the issue comes in. This places the majority of dispute within the scope of hardship rather than force majeure. In the UAE, this addressed under Article 249 of the current law and Article 224 of the new law. So where do we start? The key starting point is a classification. For each contractual obligation, parties must assess whether performance is genuinely impossible or merely more difficult. And this determines the applicable legal remedy. From practical perspective, parties should first review any existing contractual mechanism, such as a price adjustment or escalation clauses, and rely on these where available. Where such mechanisms do not exist, UAE law provides that hardship is a mandatory doctrine and cannot be contractually excluded. Another very important point here is documenting causation. Parties must maintain clear, timely evidence linking the disruptive event to the impact on performance, including affected routes, shipments, cost, and communications with suppliers and insurance. UAE courts requires a direct and evidence-based causal link. And finally, parties must comply with contractual procedures, including strict notice requirements and timely submission of evidence.
Okay, excellent. Dean, bring it home. What should they be doing right now on a day-to-day basis with their evidence, their finance, and dispute readiness?
Sure. So I don't mean to ruin the mood, but many companies across the region and many of the people attending this webinar right now are already in the early stages of a potential dispute, whether they realize it or not. And even though every contract and every situation is unique, there are a few general recommendations that may be helpful to many of you attending this webinar right now. First, just check the contract or contracts that you're worried about, and specifically check the governing law. So GCC civil law contracts carry the mandatory statutory protections that we've discussed today. For example, hardship and impossibility protections that cannot be contracted away. But foreign law contracts, like English law contracts, for example, probably do not. So there's no equivalent statutory hardship doctrine under English law, and everything depends on the contractual wording. And as we know from working and practicing in this region for so long, many contracts that are governing performance of services or events or transactions in this region are not necessarily governed by the laws of this region. And then further complicating this is that sometimes local law is actually specialized sub-jurisdictional law, like the laws of ADGM or DIFC or the Qatar Financial Center, which are also based on English law. So first thing to do after this webinar is actually check the contracts, check them in detail, and check the governing law clauses. Those are very relevant. Second thing to do, and I'm sure this is something that many people have been doing already, but they should continue to do so, is to take good notes and to stay very organized. Your documentation should capture everything that may be relevant in a potential formal dispute. So a few examples would be official government announcements, both public and publicized and reported on government outlets and on news channels. And then maybe even less noticeable things like notices or circulars that maybe some recipients received, but the general public did not. All of this is very, very relevant, and parties that are worried about potential disputes should keep very good evidence trails of this with dates as well. Another example is specific shipments that were affected or routes that were closed with dates and supporting evidence. Another one, which is very, very technical, very financial, which is price comparisons before and after the disruptions of the past month. So if you know that something would have cost a certain amount on February 27th, and then on March 15th, it cost something very different, it's really helpful to have those comparisons before and after. And then finally, just internal documentation, which is internal decision-making records, board minutes, things like that, things that demonstrate all the decisions that were taken by affected parties and the reasons behind them. And the third thing to be aware of, the third big recommendation that we would make is to not just focus on contracts or clauses in isolation, but to look at the entire sort of back-to-back contractual chain. Force majeure and hardship events that affect one contract rarely affect in isolation. If you're a main contractor for a very big project, then you have to think about how these events maybe impacted one of your subcontracts and then how they affected in turn your contract with the main client or employer. So it's important to map the full contractual chain back to back to back as much as possible.
Excellent, excellent. All right, good. Well, look, I want to thank the panelists for this comprehensive discussion. But before we close, let me share what we're seeing on the ground right now, because this isn't really theoretical for us. Across the region, our clients are fielding calls every day from contractors, employers, project financiers, and supply chain participants who are facing real disruptions right now. We're seeing shipping operators reroute or suspend voyages through the straits, war risk insurance being withdrawn, airspace restrictions affecting the movement of personnel and cargo, and supply chains that were already under pressure are reaching a breaking point. In the construction sector specifically, we are already seeing disruption of supply chains with pronounced impacts on logistics, including severely limited transport routes, reduced cargo and shipment availability. Employers should expect contractors to start raising force majeure clause if the performance has been impacted. And in many cases, they have. What our teams are consistently finding is, in most situations our clients are facing today, performance remains technically possible, but significantly more expensive. That's hardship territory, not force majeure. And that distinction, as our panelists have explained, changes everything. The classification governs whether you seek a contractual claim, judicial rebalancing, or both. But we want to hear from you. Well, we have a few minutes left, and I see that there's a number of questions in the chat. And I think we just want to, let's throw them at our panelists and see how they do with the same. One I see from Izzet, is there any guidance on the definition of temporary impossibility? Is it a variable definition based on the type of contract at issue? Any thoughts, team, on temporary impossibility?
I don't want to name any names, but I would say that one recent event in the news, and I know that that party has an absolute army of excellent lawyers. I suspect that it was very well researched before they made this decision. Temporary impossibility was invoked because the underlying obligation was the delivery of energy products over a long period of time to many foreign clients, all of which essentially originated from one place. So I think that's a pretty easy example of temporary impossibility. That particular entity was no longer legally or even physically able to extract or to deliver their energy products, but they're very confident that they will be one day. So that's, I think, a pretty easy example of temporary impossibility. I think it can get more complicated than that, but I think that's an instructive one.
Okay.
Yeah, I mean, adding to what Zina has just said, in simple terms, temporary impossibility merely suspend the obligation, and on the other side, permanent impossibility extinguishes it. That's in simple words.
Oh, agreed. Another good question I see from Ingrid. Can you elaborate on how geopolitical considerations made at the contract signing are evaluated or tested at the time of force majeure? It's a good question, especially when you're in the Middle East. Because, for unforeseen circumstances, that the key word is unforeseen. Is it really unforeseen when you're living in the Middle East in terms of issues arising?
Yeah, it kind of feels like we're being picked on here. It's almost like, especially people that are not based in the region are saying, well, we told you so. You should have seen this coming.
Right.
I think that this is one of those situations where it's going to be extremely fact specific. I think it's going to be very difficult to say that we know exactly how a court would rule on this. I do think that it's very relevant, and the laws are, I think, very well drafted on this point, which is that the same contract that might have had the same commencement date but a different execution date may be analyzed very differently in the courts under the civil codes across the region. And that's something that I think I think it's very likely that we're going to see things like that come come across our door, where it became very relevant knowing the exact moment at which commencement started, but the negotiations began and the effective date of the contract was.
Right. I'd like to direct this question to Hagi, because I know he does a lot of this work. To what extent may the doctrine of force majeure and hardship under the civil code be invoked in relation to employment contracts? That's going to be a big question, and we've seen it come across already. And it's from both sides. The employer side, does he have to pay when their source of revenue has been cut off? And what about from employees who can't get back to the region for different issues?
Of course, I think lately working remotely is actually makes life easier with that respect. But we have seen in a lot of GCC countries now, due to the current circumstances, they allow working remotely, of course, depending on the function of the employee. But indeed, I do believe that if it's impossible to perform a work, force majeure can be one of the causes for the termination of employment contract.
Okay. And look, we've got 3 minutes left, and we have a number of questions. I think what we're going to do is get to them and try to send out emails to each person individually only because we have to wrap up in the next couple of minutes. So I just want to, leave the audience with a few things. Number one, there's three doctrines that you have to be aware of. The one spectrum, the hardship, the sword, responds when performance has become excessively burdensome. Force majeure, the shield, responds when performance has become genuinely impossible. Impossibility of performance produces automatic dissolution when that threshold is crossed. The line behind them is not conceptual, it's legally decisive. One critical asymmetry you must internalize: hardship and impossibility cannot be contracted out. This is the biggest difference between Arab civil law and Western common law. Force majeure as a liability defense can be, and that asymmetry operates in every contract that we governed by GCC law, regardless of what the drafting team intended and regardless of how sophisticated the contractual force majeure regime is. And one urgent practical message: classify, notice, document, mitigate, and renegotiate now. The evidentiary record is being built today. The notice deadlines are running today. The Saudi renegotiation obligation is accruing today. And if your GCC contracts are governed by English law, including DIFC or ADGM, your clients may have substantially less protection than they realize. The gap needs to be identified and addressed now. Our teams across Kuwait, UAE, Qatar, and Saudi are advising clients on exactly these questions as we speak. Please don't hesitate to reach out. We want to thank all of you for joining us today. Stay safe, stay prepared, and protect your contractual provision. Thank you, everybody.
Thank you.